Mr. Grant, where were we?
Thank you very much, my lady. What I was proposing to do now is go straight to the various grounds of our appeal on the basis that I can take them a lot quicker than I thought I might be able to take them, because I apprehend that the exchanges that occurred before the short adjournment have clarified the areas of dispute in this case, and often a lot of the aspects of my appeal.
Before you do that, may I ask a practical question? Am I meant to have, and am I in a position to have, the rolling transcript going? It wasn't, I know it wasn't set up for this morning, but I'm just, all it says is no session in progress.
My understanding, my lady, is that the parties have agreed not to have a rolling transcript. Have I got that wrong?
No. I was expecting to have one, but I'm in the same position as your ladyship.
Okay.
No session in progress.
Oh, sorry, I was under an apprehension it was going to be transcripts at the end of the day, but apparently a very Rolls-Royce agreement was reached between the parties. But in any event, it's just not working.
Okay, that's fine. Just I don't want to endlessly look at it in the hope that
I
it
don't think
might.
it'll work this afternoon either, from my impression of what they were doing before
Lovely.
the court came.
Let's carry on. Sorry about that.
Not at all. So, my lady, I come to the first of my grounds, and we can pick this up in my skeleton argument at paragraph 20, page 8. And the court will see, I'm not going to stick to the skeleton, I'm just placing it in the framework of the skeleton. The court will see there that ground one is as follows. Having rightly found that the agent was a fiduciary, the judge erred in law in his analysis of the scope of the duties of the fiduciary agent and the consequential finding on the basis of the attenuated scope that the broker was not in breach of its fiduciary duty. We can pick the judgment up at paragraph 147, that's tab 9, at page 125 of the external pagination. Same button, call button. And there, the judge posed the question, what was the nature, scope and extent of any fiduciary duties? He starts his discussion under that question with a statement with which, of course, we do not cavil in the slightest. I do not think it can sensibly be denied that the commission arrangement in this case gave rise to a conflict between the interests of UW and those of its principal claimant. He then quotes from paragraph 33 of Herstang, which I've already shown the court, and says rightly at para 148, this case is no different. And then what happens in the judgment for the next 50 or so paragraphs is that the judge poses the question about, effectively repackages the fully informed consent question, which is the conventional way that one asks whether or not a breach of fiduciary duty or a conflict has been ratified or authorised or consented to. He repackages the question of fully informed consent with a series of paragraphs dealing with the supposed duty or extent or scope of the fiduciary's duty of disclosure. And one sees at various stages in this section of the judgment, I don't take the court to them, but for instance at 160, at 164, at 182, at 183, at 194, we see the judge asking slightly different formulations, but essentially the same question over and over again, which is, did the fiduciary, in this case Utilitywise, have a duty to disclose fact A or fact B or fact C to the principal? Now, we say that that set of questions involved a misunderstanding of the nature of fiduciary duties and a misunderstanding of the way the law asks the question whether or not a principal has consented to its fiduciary's breach or the conflict that the fiduciary may be subject to. And we make, in that context, a number of overarching legal submissions. The first is that fiduciary duties are traditionally understood to be negative in character. They are prohibitions rather than express positive duties to do X or Y. And one sees that stated in Bosted at paragraph 6-39. I don't take the court to Bosted, but the reference is, for the court's note, is at tab 54 of the authorities bundle, page 1448 of the external pagination. The second principle that is applicable is that those negative fiduciary duties, the no profit rule, the no conflict rule, and so on, are strictly enforced, and are strictly enforced pursuant to a policy of the law that has been extant for at least 300 years to ensure the undivided loyalty of the fiduciary to the principal. In our skeleton argument, we cite well-known dicta, starting with the decision, the judgment of Sir William James in Parker and McKenna, which obviously is one of the great classics of the equity canon. That's tab 4 of the authorities bundle. We then go on to cite the decision of Lord Justice Scrutton in Rhodes and McAllister. We go on to cite the decision of the Court of Appeal in Imageview and Jack. And they, as I hardly need tell this court, that line of authority, and one could have quoted dozens of others to similar effect, all speak with one single powerful voice, which is that the duties of the fiduciary will be strictly enforced through principles of equity. I notice, my lady, that my learned friends, faced with that bank of authority, dismiss Parker, Imageview and Rhodes as containing dicta that are merely obiter. That's paragraph 18 of my learned friend's main skeleton. I shall leave that submission for the decision of the court. It may be thought of as a fairly surprising submission. Parker and McKenna must have been cited dozens of times since it was originally decided, and in particular, the court may recall cited with emphatic approval in the House of Lords in Regal and Hastings, 1942. We haven't loaded the court with authorities that are so well known to this court, of course, in the authorities bundle. Proposition 3, my lord, my lady, is that it is right that the nature of a fiduciary's duties may be moulded by the underlying contract, if there is one, between principal and fiduciary. And of course, one need only remember back to the House of Lords decision in Hilton and Barker Booth to remember that principle. But here, there are no contractual duties invoked by my learned friend in the contract between agent and principal that could in any way temper or mould the classic canon of fiduciary duties identified, for instance, in Mothew and Bristol and West Building Society by Lord Justice Millett, as he then was. Proposition 4, it follows, therefore, that here the broker was subject, without any form of contractual curtailment, to the core fiduciary duties we see in Mothew and restated by Lady Arden in the Children's Investment Foundation very recently, and where her ladyship refers to the no profit and the no conflict rules, which are particularly in issue in this case, as, I quote, part of the fiduciary's core responsibility. Proposition 5, and it follows that the only way the fiduciary could excuse its breach was by positive proof of full disclosure to its principal and this is a separate constituent, fully informed consent by that principal. Disclosure and consent. Now, that five-stage analysis was the proper way the court below should have embarked upon the task of determining whether or not the found conflict, as the judge found, had been ratified or authorised by the principal, i.e. my client in this case. To pose the question as being one of extent of duty or scope of duty was to misapply canonical fiduciary principles. And it would appear that the decision to do that on his lordship's part below was highly influenced by the decision of this court in Medstead, which the court will find at tab 34 of the bundle. And I wish to briefly dwell upon Medstead, if I may. It's tab 34, which is, for those with a hard copy, is at bundle 2. Now, I haven't got long to spend on Medstead, and I'm sure the court will remember the case well. But Medstead, it's fair to say, was a case involving very particular and possibly remarkable facts. And the particular facts that I wish to draw to the court's attention or remind the court of are that in that case, the principle of the fiduciary was not a litigant before the court. It made no complaint whatsoever about the fiduciary's behaviour. Instead, the litigants, in a very complicated fact pattern, I should say, set of facts, the litigants before the court were, as claimant, the agent fiduciary, as was held by the court, and B, the defendant who had entered into a contract with the principal and had received commission, so it's like a double agency in one sense, commission from the principal, being certain wealthy Greek and sophisticated Greek investors, and had, out of the commission it received from those investors, which commission it charged to allow them to invest in contracts for difference with a, down the line, a further, I think they're known as a second tier platform, had divided up that commission with the claimant. And what, it's complicated, I haven't got time to go through it, but essentially what had happened is that the defendant, Collins, which had renamed itself Canaccord, so that's why it says Canaccord on the face of the judgment, Collins Stewart had decided to cut out Medstead, the claimant, so as to deprive it of monetary remuneration, and had done so, it would appear, with the connivance of the principal. And one sees that at paragraph 16 and 17 at page 709 of the external pagination. And the claimant sued on the contract it had with the principal, with the third party Collins Stewart, which had received the commission, and simply said, you owe me X thousand or $1 million pursuant to the contract whereby the commission is divided between us. And profoundly unattractively, one might think, Collins Stewart defended that claim on the basis that, well, it may be that I'm contractually liable to pay you under a contract I freely entered into with you, Medstead, but aha, your principal, who has never come anywhere near this court and makes no complaint, was the subject of a breach of fiduciary duty because you didn't tell the principal, the principal, the Greek investors, about the precise amount of commission that you were receiving via the split between us. And therefore, as a matter of public policy, you should be debarred from bringing this claim. Now, one might well think that that was a cynical and unattractive defence, and this court duly agreed with that, as I read it, and allowed the agent's appeal against Canaccord, Colin Stewart. And one can well understand why the outcome was as it was. But in the context of discussing the question of breach of fiduciary duty, Lord Justice Longmore talked in terms of scope of duty. And that's language which I do not believe one finds articulated in any earlier authority when deciding the question of fully informed consent. I should say I don't suggest the outcome of that case was wrong in any way. I suggest that the approach that was taken by the Court of Appeal in that case was not strictly in conformity with standard fiduciary principles in determining the question of whether the fiduciary breach, whether the conflict of interest had been ratified or not by the principal. It is also fair to say in that case that there were two other significant features which explain the outcome and the reasoning. Feature one was that the principals, as I've said, were obviously people of extreme sophistication who wished to engage in highly technical and sophisticated trading activity. Feature two is the fact that the principals knew how much commission they were paying because they were actually paying it to Colin Stewart. A defined percentage was paid to Colin Stewart. They knew the commission that was being paid. The only thing they did not pay, they did not know, was precisely how much of that commission, which was a percent, I think it was 0.7% of the amount invested, was being split between claimant Medstead and defendant Colin Stewart. And what is critical is that there was no submission that I can see from Canaccord, from Colin Stewart, setting out the nature of the conflict that Medstead was subject to and the elements of disclosure that were required by way of defence to cure or ratify that breach. The Colin Stewart didn't, I mean, no doubt, because they're in a rather difficult position given the sheer cynicism of the defence that was being mounted, did not set out any kind of coherent analysis to the Court of Appeal as to the nature and extent of the conflict. And those are words I quote, of course, from the Court of Appeal in Herstanger, the nature and extent of the conflict. The third point, I suppose, that one might just dwell upon in Medstead is that although finally the Court of Appeal decided that Medstead was indeed a fiduciary of the Greek the sophisticated and wealthy Greek investors, it's fair to, I think it's fair to say that it reached that conclusion pretty hesitantly in the circumstances of that case and moulded an outcome which ensured that justice was done. Now, my learned friend seeks to place great reliance on Medstead. It is a decision that I note some aspects of it are doubted in Snell, the most recent edition of Snell. That's Authorities Bundle, tab 57, page 1468. I haven't got time to show the court that. And secondly, I notice that in Johnson, the outcome of Snell is of Medstead is refashioned. And can I just show the court? I think I should show the court this.
Just before you go away from Medstead, can you just quickly point, certainly me, to where you say it goes wrong?
You
say it goes wrong. Well, you do.
I don't in any way quibble with the outcome.
No, the
Can
analysis.
I make that respectfully clear?
The analysis. I mean, scope. I think you say, scope is something that Lord Justice Longmore introduced off his own bat, if I can put it that way,
Para 34, yes.
rather than it being used anywhere else or in any of the authorities.
Well, that's what I do say. With the greatest respect, I say it's a newly minted conception. It may have yielded the right answer. I don't quibble with the answer, and the facts are very particular in that case. But what I don't,
I'm assuming that I'm assuming therefore you don't agree with the start of paragraph 42, the way it's put. If you don't, well, if you do, say so. But if you don't, you just tell me in short measure why not.
It doesn't matter to the outcome of Medstead. Actually, I'm not quibbling with the overall.
I've got that. You do.
Got that. The reason I suggest paragraph 42, I would respectfully suggest, is something of a new departure in the way that one analyses the authorization or ratification, as indeed this is what in reality is all about, of conflicts or fiduciary breaches. And the reason I say that has gone wrong is because the fiduciary duties are negative in nature. What is perhaps being the very slight misstep that is being made, 42, I would respectfully suggest, is the court, instead of properly analysing the question of consent as a defence by the fiduciary or the third party who seeks to take advantage of the breach, is asking whether there was a primary duty on the fiduciary of disclosure. The law's never looked at fiduciary duties in that way in terms of primary obligations of disclosure. It's always asked the question whether or not the fiduciary, assuming it's just a principal fiduciary claim, has, by way of defence, been able to discharge the duty of showing that sufficient disclosure was given, not by way of primary duty, to cure and ratify the breach, so as to lead to consent. Of course, it's disclosure and then consent. So,
you wouldn't quibble, would you, with paragraph 46, the other way of putting it? The last two lines of 46.
I would therefore hold that on the facts which the judge found, Medstead was not under duty to disclose the exact amount of the commission. It was due, or to put the matter, to the extent that Medstead was the fiduciary of its clients, it was not a breach of that duty for it not to disclose. In a roundabout way, I wouldn't quibble with that, on the basis of what appears to be found there, and I think this is the way that Johnson analyses it, I should say, and I'm going to come on to, is that sufficient disclosure was given to ratify the breach, and that I have no problem with as a legal approach. But can I just very briefly, we can put away Medstead, and we can pick up, if the court wouldn't mind, this is in Authorities Bundle 4, tab 52, first round, or Johnson, I should say. Para 51, I do it, so tab 51, I do it. And we can see there the way that Medstead was read at paragraph 100. Page 1383 of the external pagination. It is precisely because the brokers were in a position to take advantage of their vulnerable customers, and there was a reasonable understanding expectation they would act in their best interest, that they owed them fiduciary duties. So far, so good. There was obviously reliance on them to act in good faith. So far, so good. Medstead is distinguished on its facts because the borrowers in that case were financially sophisticated and so on and so on. I made that point. Even in Medstead, the relation was held to be a fiduciary one. It's fair to say, with some reluctance, it would appear, and quite understandable reluctance, the difference was that the fiduciary duty did not extend to expressly informing the clients how much commission the broker would be paid. They could be expected to ask if they wish to know. Put another way, says the court in Johnson, on the specific facts of Medstead, and I should say that Lord Justice Longmore was very punctilious in making clear how fact-sensitive the case was. There was sufficient disclosure for there to have been informed consent, and that's the right way. And I think my Lord Justice Zacaroli may have been making that point provisionally by reference to paragraph 46. That's the interpretation at paragraph 100. And if we then go on to paragraph 132 of the same judgment, we see an implicit rejection of a scope of duty analysis. Applying that analysis to the particular circumstances underlying these appeals, the essential facts which made the receipt of the commission a breach of fiduciary duty are: 1, the fiduciary relationship, tick here; 2, payment of a commission to the fiduciary puts you in a position of conflict, tick here, unless there is full disclosure of consent by his principal, here the consumer. That's the real question to his receiving that payment. There will be no breach of duty if the payment is made with the informed consent of the consumer, but informed consent is a defence to the claim for breach of fiduciary duty. Lack of consent is not an ingredient of the cause of action. And I particularly place reliance, respectfully, on that. As Hurstanger confirmed, it is incumbent on the fiduciary, or the lender as the case may be, or the supplier as the case may be in this case, to establish that there was fully informed consent, which they cannot do in a partial disclosure situation. And I respectfully say the essence of the law applicable to this case is well captured, respectfully, at paragraph 132. My lady, we make 2 other points in our skeleton argument, which I don't propose to elaborate on now. The first point we make is by way of a hypothetical, which I do not wish to go over now. Your lordship and my lady will have seen that hypothetical. But we say it is a pretty illuminating hypothetical, because on the judge's analysis, it would appear that there was no duty whatsoever, if that's the way the judge analyses it, on the part of the broker. Having said the commission is paid, it can then, with impunity apparently, then push the business in favour of the lender, the supplier, that will pay it X% commission, as opposed to the supplier who will only pay it half X% commission. Apparently the law of fiduciaries, on the learned judge's reasoning below, permits that behaviour, and we say patently not so. The third and final point that I wanted to make on this ground, because I want to move on, is that, and it may be this point is relevant to the reasoning of the court below generally, is that we see constantly being said by the judge below that both in the context of so-called scope of duty and in the context of fully informed consent, I might as well just deal with it now, that my clients are somehow stigmatised or criticised for failing to ask the follow-up question, failing to drill down into what's actually going on. What actually, tell us more about this commission, Dean, I suppose is the question, is the way the judge put it. Now, a completely unreal, factually unreal proposition. But given the circumstances in which these phone calls took place, and the court can read them, has the transcript. But putting aside the factual unreality of that point, it just simply involves a profound misunderstanding of the nature of fiduciary obligations. The principal's not expected or required to do anything at all. And my lords, my lady, one need only go back to the classic decision of the Master of the Rolls in Dunn and English, which we've quoted in our skeleton argument, to see that at work. And I would invite the court to read the three pages of Dunn and English, where the Master of the Rolls at that stage in the 1880s makes it absolutely clear that there is literally no duty whatsoever upon the principal to make inquiry of its fiduciary as to the nature or circumstances of any conflict it may be subject to. And the unreality of my learned friend's client's position on this point, and indeed it goes to the heart of his defence to this appeal, is revealed by paragraph 24 of his main skeleton argument, when he says, with an apparent straight face, that my client should have been on its guard. It's the first time I've ever heard it suggested that a principal has some sort of duty to be on its guard as against its fiduciary, whom it trusts and should trust to be acting in its absolute best interests, with an undivided and razor-sharp loyalty to itself. I'll say no more about that, but the references in the judgment where the judge plainly allows his judgment to be informed, and the outcome of his judgment be informed by this supposed duty of inquiry on the part of the principal are paras 177, 186, 195 and 224. In each case, a misconception is being allowed to inform the judgment. That is all I want to say about ground one. I now move to ground two, which is, I think it's fair to say the court below saw ground two as a sort of similar, a different way of perhaps asking the same question. But it's right that we ask the right question in the right way through the right lens of fiduciary law. And ground two, which we can pick up in my skeleton argument at core bundle tab 4 at paragraph, forgive me, paragraph, sorry, it's tab 3, I do apologize, at page 29 of the external pagination. We can see ground two set out there in my skeleton argument. The judge erred in law in his analysis of the requirements of the principal to give informed consent to the breach of duty, and it follows that C had given, and it follows, I mean that's i.e. the judgment that is wrong, that C had given its informed consent to the broker's breach of duty. Now, the judge dealt with this aspect of the case at, if we go to tab 9, at paras 212, this is page 136, to 139, para 226 of his judgment. He had dealt with the scope question over a number of pages up to paragraph 195, and I've already dealt with that under my ground one. I approach ground two in 4 stages, briefly. Stage 1 is the law. Now, again, the law on fully informed consent was classically stated by the master role, Sir George Jessel, in Dun and English back in the 1880s. That says more than simply there is no duty of inquiry on the part of the principal, but sets out the constituents of fully informed consent in very plangent terms. And if I could briefly invite the court to pick up bundle 1 of the authorities bundle, this is tab 3, page 46. External, page 46. The headnote captures the essence of his lordship's judgment in Dun and English well. And the relevant pages, which I don't have time to take the court through, but I would invite the court respectfully to remind itself of pages 533, which is page 55 of the external pagination, through to 536. We can just see it at the bottom of 533, internal. It's not enough for an agent to tell the principal that he's going to have an interest in the purchase, or to have a part in the purchase. He must tell him all the material facts. He must make a full disclosure. And the tenor of the reasoning continues in the same vein. And we see at page 57 of the external pagination, halfway down the page. Now, what is the meaning of knowledge which he himself is possessed? Full knowledge of all that he knows. And then the point about being put on inquiry a bit further down, halfway down the page. And then again, 536, page 58. For reasons of policy, it's not sufficient to put the party on inquiry. he must not only put the party on inquiry, but give him a full information and make full disclosure. Now, my lords,
The long and the short of it is, we've seen a number of authorities where the expression fully informed consent is truncated to informed consent. And I think you'd say, actually, it would be better if we stuck to the three words, not two.
I would say that, and I have the great benefit behind me of Lord Newburger in FHR, which we haven't put in the court's bundle again for fear of overloading the court with very well-known authorities. But the court may recall paragraph 5 of Lord Newburger's judgment in FHR, and I quote, "Because of the importance which equity attaches to fiduciary duties, such informed consent, in quotation marks, is only effective if it is given after, quotation marks, full disclosure," to quote Sir George Jessel in Dun and English. So Dun and English remains as alive and well now as it was back in 1872 when the decision was handed down. And the most recent articulation of the law by this court is in the supplemental bundle filed yesterday, forgive me for another supplemental bundle, which is the decision of the court in Trafalgar multi-asset trading. And I don't know if your lordship and my lady has that. It's a slim volume of new material. It's very short. Little supplemental bundle.
I did have, but now I don't. Oh,
Thank you. I've got another
Trafalgar
copy of
multi,
my
I have
lady
it,
here.
yes.
Yes. If you go to page 28, external pagination of that ancillary bundle, in the case of Trafalgar and Hadley, the law is stated at para 42 in a way which we entirely respectfully embrace. And you see again the wellspring of Dun and English still feeding and watering the law now. And
presumably you would also say, in order to be able to give that fully informed consent, what is necessary to be provided to you is partly also dependent upon your level of sophistication.
I'm going to come on to level of sophistication in a slightly under ground 3, but I will come straight back to that after I've just made some submissions on this area. So that is the nature of fully informed consent, the legal conception thereof. The question of materiality, as in how granular must the disclosure be? The materiality question has been decided in many cases, but one can find it stated with, if I may say so, great precision by Mr. Justice Simon, as he then was in FHR at first instance, where at paragraph 79 he says the relevant facts that needed to be disclosed are those facts which, to quote from the judgment, might have affected the principal's decision, might have affected. And that is, I should say, my learned friends accept that as a proper statement of the law at paragraph 28 in their skeleton argument. And for the note, FHR at first instance is at tab 26 of the authorities bundle. I won't go to it.
What it's worth, it's what Lord Justice Stuart Smith said at paragraph 43.
I should have just simply looked there, and with even greater authority, of course, of the Court of Appeal, and a very recent Court of Appeal. You're quite right, my lord. I apologise for overloading you with authority. Now, so that's section 1 of my submissions on ground 2. Section 2 is what is the nature and extent of the conflict that the agent was subject to here. It is, we suggest respectfully, vital to identify, to use the language of Lord Justice Tuckey, the nature and extent of the conflict in order to understand and answer the question, what was required to be disclosed. And I've laid much of the groundwork for this already, so I can take it, I think, relatively quickly. We say the relevant facts that are displayed in this case and which required proper disclosure, if they were to be if the conflict displayed by them was to be ratified or authorised, were as follows. And for the court's note, we have in our skeleton argument set them out at paragraph 40. But to take it orally and quickly, what we have on display here is a frankly remarkable scenario where the broker is, I mean, to call him incentivized to push business towards Engie would be a considerable exercise in understatement. We've seen what the side letter does. Effectively, the broker in every time the broker thinks actually British Gas is a better deal for my client rather than Engie, the broker is exposing itself to having to pay back part of all of that £2 million it's had up front. I mean, to describe that as incentivisation, as I say, would be an understatement. Ergo, too.
Sorry. So you're saying the side letter was something which ought to have been disclosed in order for there to be proper.
Absolutely.
Okay.
The side letter and the conflict that it created, because essentially.
Although curiously, the side letter is something you don't refer to in paragraph 40. I'm not disagreeing with you that it should have been disclosed.
Well,
I'm just saying you don't actually refer to it in paragraph 40, do you? Just out of interest.
It may be we don't, my lord. In our defence, I should say that your lordship had rightly said that our skeleton should be 25 pages long, and we were trying to squeeze ourselves within that pagination length. Sorry? My learned junior says that no, it is referred to top of page 31, my lord. In our defence, by virtue of the side letters, the broker had an interest in channeling C to the supplier. Does your lordship see that?
Yes.
This is skeleton argument, subparagraph 2, top of page 31 of the external pagination.
Okay, in which case, yes, okay, well, sub 2 then covers two different types of payment. The first is the broker specifying its own commission. That's what I'd call the consumption-related commission.
Right.
And then the second is the side letters. It's referred to as the, I can't remember what it's called now. It's the
Campaign commission.
Campaign commission.
Yeah.
Right. So those are two different things.
Quite.
In fact.
Quite. So to take it as quickly as I can.
Apologies to your junior there, but it does actually mash two different things
No,
together.
it does. I'm going to have words with him after court.
I blame the proofreading leader.
The Professor Davis is entirely exonerated. He was on the second skeleton. So to be absolutely serious though, we have a situation. Fact one or situation one is we have a situation where, as I've said, the broker would be, from its own personal point of view, quite mad to suggest to its customer that British Gas is better, because it knows that every time it does that, it's coming under a liability to pay back some portion of that £2 million. That effectively leads to point 2, which is a point that Johnson picks up, and I come on to, that as a result, the agent had to say to its principal, look, I know we say in our website, we've said to you, we're on your side, we're independent, we're going for the best deal, but we can't give you unbiased advice because we are so conflicted by the arrangements we've enmeshed ourselves in with with Engie. They just can't give unbiased advice, and that should have been made clear. They should have made clear or an aspect of the conflict was. By the way, you do realise that if we're feeling greedy today, you're going to be paying more electricity. It's an absolute fact that if they'd said, actually, 5.6p per kilowatt hour as commission for what must be half an hour's work, it's just not on. We're only going to charge a penny.
Mr. Grant, I think we've got these points, but what you were telling us was the facts which needed to be given for proper disclosure to have been made in order that fully informed consent could be given, And I think they are, and you're satisfied and happy that those are set out in the sub-paragraphs of paragraph 40 of your skeleton.
I am. And in essence, what the disclosure that was actually given, this is my third heading, which I'll take as quickly as I can. The disclosure that was actually given, we've already looked at it. It is the garbled and veiled language of a hasty 10-minute sales pitch or sales conversation on the 21st and 29th. Your lordships and lady have looked at that. I made submissions on that. There's the opaque language in the contract, insofar as Mr. Gadesley ever saw them, which he didn't, which the judge merely finds was sort of came to somebody within the claimant company without, we don't know how. There's no suggestion that the company that Engie didn't provide any disclosure of provision of the contract. And even if anyone did study that contract, they'd have seen the most obscure and opaque language, which, by the way, contains a falsehood, because that language says the broker may be paid.
These are submissions in relation to the other side of the coin, and the point that you're making at the moment are the things that ought to have been, but you say were not.
What I'm looking at is
So let's just concentrate on those things which ought to have been, which you say are in those 7 subparagraphs.
Quite. I'm now looking at what was disclosed and showing and seeking to demonstrate to the court quite how inadequate the disclosure actually was, and I'm just making a very brief reference to the fact that if one looks at those opaque words in the centre of the contract, the standard form contract, in fact they contain a falsehood, because they say commission may be paid to the broker. In fact, there's no suggestion it wasn't paid every time. So in itself misleading, double misleading, because it also doesn't explain how it might be paid and whether it's out of the commission or whether it's out of a standing charge or any of the other charges we saw on the second page of the contract. So
Okay. Well, there are 2 things that you really place reliance on, as I understand it. The first is, whatever meaning you give to the word commission, what wasn't said is, and by the way, it won't come out of the supplier's pocket, it'll just be recharged to you. Because a commission could simply be, it's going to come out of the supplier's pocket. That would have been one meaning of commission, and you say they needed to make it very, very clear that whatever commission it was going to come out of the client's pocket. And then in relation to the incentive for the campaign incentive, it actually incentivized the broker not in fact to look anywhere else.
Right, two more points, which are absolutely vital. One is I say, as a matter of the court to decide this question, of course, the quite extraordinary situation where the agent, without any let or hindrance upon it, could just to say, oh, I'll go for 6p this time. Let's go for the full 100,000 on this half an hour's work, or I'll go for 1p.
Yep.
But should I go 1p or 6p? Oh, I think I'll go for 6p because, hey, why don't we earn 100,000 rather than 20,000? I mean, that just, I'm speaking in vernacular language to try and get to the heart of the remarkable scenario that this case throws up. And the second point I wanted to make, just by way of very brief gloss, is the other aspect, or another aspect of the conflict which required absolute disclosure was, if we recommend 5 years, that may not be, we are incentivized for our own benefit to recommend a 5-year contract because we'll make 5 times what we'll make if we recommend a 1-year contract. Now, that is, again, I would suggest, a totally remarkable fact, which, if it was to ratify the breach of fiduciary duty, required the most minute and clear statement. And of course, the reason it wasn't, not that it matters necessarily to my case, but the reason that it wasn't made is because anyone told those facts would have put the phone down within seconds, and the TPI must have known that. My lord, my lords, my lady, I come briefly to the judgment. It's important we see how the judge dealt with this point. I've told you, my lady, that the relevant part of the judgment is at paragraph 212 to 226. it's apparently an academic question because of his decision on scope, and that's, you may think, quite surprising, that when we have a breach of fiduciary duty and a conflict that's been found, it's academic to decide whether or not there's been fully informed consent. The court analyses the law over a number of paragraphs. The heart of the decision, well, I should say, para 217 involves a mistake, because Herstanger does not, contrary to para line 3, talk about the scope of the agent's fiduciary duty. That's just wrong in terms of its interpretation of Herstanger. We say that the heart of the decision at 224 and 225, I think the answer is that it was, and that the defendant has satisfied the onus of establishing fully informed consent. Then there's some reference to smart meters and something called FITT, which I have no idea what the relevance of that is whatsoever to fully informed consent. Insofar as it received the defendant's contracts, commission was mentioned in them. You've heard submissions on that. And the fact that if commission was payable, it may be added to the unit price, insufficient. Then there's some reference to the agent's terms and conditions. Your lordship, my lady has seen, my lords have seen that. No one ever suggests that anyone looked at them. Neither Mr. Forster nor Mr. Gazy nor the claimant company were naive or vulnerable. We'll come back to that. Of course, there are the phone calls to Mr. Forster and Mr. Gazy. And then this, and their failure to drill into the commission element once told about it. That is a very substantial legal error on the part with respect to the part of his lordship below. And then we come to 225. I would also add in coming to my conclusion that there was sufficient disclosure, it is right to note that the fact that commission was added to the unit cost was a known industry practice. And apparently the foundation for that statement is this fact sheet, which I was very careful to show the court, because I didn't want my learned friend's case not to be properly put. To that extent, insofar as it reflects trade usage and custom, there's no finding on trade custom, and the court will know that trade custom is very tightly circumscribed as a legal principle. It actually obviates the need for specific informed consent because the principle is taken to know of the trade custom and to have consented to it. So essentially, because there's a fact sheet somewhere in the world in 2015 created by Ofgem, why would Mr. Forster and Mr. Gazeley look at that fact sheet? No answer given by the judge. Because it's out there in the world, my client is taken to have consented to the trade custom. It's just, my learned friend Mr. Turner will spend a little time on this when I sit down, but it may be unnecessary for him to spend too much time persuading your lordships and my lady of the error of 225, which is integral to the reasoning process in this judgment. And one sees throughout the analysis in the judgment, from paras 148 through to 226, continual invocation of this unheard of concept of being in the public domain in the context of a fiduciary duty case, and the obligation to ask, the being taken to know a trade practice, and so on and so on, and vitiating at every stage.
Are you only supposed to know of a trade custom practice if you're in the trade?
My lord has it in one. It's inexplicable, that paragraph. I just simply can't assist the court on what is going on in that paragraph, with the hugest respect to my lord below. So that's, for what it's worth, the court's reasoning below on fully informed consent. We say it's wrong. We say it's quite obvious that my learned friend, acting on behalf of Engie, failed to discharge the duty upon it if it wished to cure the breach which it had procured of showing full information and separately fully informed consent flowing from my client. I don't know where the consent is to be found, other than perhaps in a Mr. Phil Gazeley's plaintive word yep, as he's waiting for Mr. Jackson to put the phone down so he can go away on his weekend.
I think there was a little allusion in that submission. You said Engie has not satisfied the burden on it to show this fully fully informed consent.
Yes,
So at the moment, we're dealing with the question of whether there was a breach of fiduciary duty.
right.
And for that purpose, there needs to be fully informed consent for there to be no breach.
I understand.
The second question is a rather different one.
The elision, my lord, derives from para 132 of
Yes.
of first round.
Which appears to contain, at least on one view, a non-sequitur.
Far be it from me to say that this court has perpetrated a non sequitur.
Let's just say potentially.
The reason that well
Let me just ask this. The third sentence, or the penultimate sentence, is there will be no breach of duty if the payment is made with the informed consent of the consumer. I think it's common ground there. Lack of consent is not an ingredient of the cause of action. Again, perhaps common ground there. Does it follow, leaving the reference to Herstanger aside, does it follow that it's therefore incumbent on the lender to establish there was fully informed consent to escape a finding of twin sextra type liability?
well, putting aside the fact that I don't accept twin sextra has any validity or bearing in this
But we're
case.
in that world at the moment.
Okay, but assuming that world, but on analysis, in fact, is a world very close to the Herstanger world, as I've endeavoured to show the court before the short adjournment. What the Court of Appeal is saying at paragraph 132, and it's saying no more than what Herstanger said, hence the invocation of Herstanger, where again the Court of Appeal and Herstanger say, because of course the agent had disappeared. There was no Mr. Dunk before the court in Herstanger. The question was between the third party, so to speak, and the principal. And in both cases, we have the Court of Appeal saying that if you are to escape a liability, a liability, a quasi-restitutionary liability, which mirrors the common law action in money had received, whereby equitable compensation is granted to require payment of the bribe or the secret commission or the half-secret commission that you paid as the third-party supplier to the agent. If you are to escape liability for that payment, then you must prove to the court as the third party, in the absence of the agent being there to prove it, because he's not a party or it's not a party, that the fiduciary duty breach which you procured had been authorised, ergo there was no fiduciary duty at all. That's why it's integral to the reasoning in Herstanger and in the reasoning in Johnson, which is the liability is that of procuring a breach of fiduciary duty. Procuration will be found by reason of the two facts, both stated in Johnson and Herstanger: knowledge of the agency, payment of the commission, and the way that the defendant can evade liability, if it can, on the facts, is by proving that there was no breach of fiduciary duty, and the only way it can prove that there was no breach of fiduciary duty is if it can discharge the burden which is upon it of showing fully informed consent. That's my answer. I'm going to come back in a slightly different angle on this at ground 5. My lord, my lady, that I think and I should say that actually, before I move on from this, it's important that we go back to first. I think the court is at paragraph 132 in Johnson. We need only turn back to paragraph 120 through to 123 to see how this court dealt with fully informed consent in the Johnson case. It was only relevant in Johnson, not in Wrench or Hopcroft. And I would very much urge the court respectfully to read those 4 paragraphs. I'm sure you've probably already done so already. But what those paragraphs demonstrate with great clarity is that the question of whether there has been fully informed consent or not is not some tick box exercise which is untethered from the actual inquiry, the preliminary inquiry that is required into the nature and extent of the conflict. It's only by understanding that conflict and its full ramifications that one can answer the question whether the information that's been provided properly conveys that conflict, its nature and its extent, to the principal. And ergo, one sees at para 121 and 123, the Court of Appeal looking at this in some considerable detail, analysing the conflict, and then saying, well, what was provided didn't go anywhere near providing full information to Mr. Johnson in respect of it. And one aspect of the conflict that her ladyship and their lordships in Johnson identified was this so-called DIC payment, which was something pretty similar to the ability in this case for the broker to name its own commission. And that particularly exercised the Court of Appeal in Johnson, as it should, I respectfully say, exercise this court in this case. And one also sees that what needed to be conveyed on the analysis of the Court of Appeal in Johnson, top of page 1389, halfway through 121, is the warning statement that the broker might, the fact that the payment might mean the broker was not in a position to give unbiased advice. We agree, with respect. And the DIC, and then there's the tie, the right of first refusal, which is actually even rather less invidious than the arrangements here via the side letter. This is para 123, and the DIC arrangement also referred to at 123. And for the court's note, the DIC arrangement, which is effectively, if I can use the vernacular, a print your own money arrangement, is at paragraph 5, is described at paragraph 5 of the Court of Appeal's judgment in Johnson. I say no more about ground 2. I come to ground 3, which, if we go back to my skeleton argument in the core bundle, tab 3, our submissions in writing are set out at paragraphs 43 onwards. That's page 32 of the external pagination. I don't have sufficient time to go through this, but I think I've probably conveyed my submissions in my written argument, and I don't think I need to spend too much time elaborating on them orally. The key question in any case is, irrespective of the sophistication or vulnerability of the principal, is whether that principal has been given the full information required, the full disclosure required to reveal the nature and extent of the conflict. In the language of Lord Justice Tuckey and Hurstanger, to bring home to them the potential conflict of interest. Now, frankly, in a case such as this, where the conflicts are such as I have elaborated in the last 10 or 15 minutes, whether Mr. Forster and Mr. Gaisley were captains of industry would have mattered not one iota. You can't consent to that which you don't know. However sophisticated you might be, if you don't know the facts, you can't consent to them. And there is no principle of law, as I hope I've demonstrated, which requires a principal to start making its own inquiries, or to use my learned friend's phrase, to be on its guard. And Dun & English has repeated time and again over the last 150 years, makes that abundantly clear. So the question of Mr. Forster's and Mr. Gaisley's sophistication or otherwise is very much an ancillary question in this case. They did not know of the side letter. How could they have known? How should they have known? They did not know that the longer the contract they were persuaded to enter into, the more commission would be coming out of their company's pocket and pouring into the pocket of the broker. How could they have known that? They did not know that the agent in this case simply could make as much money as it liked without any let or hindrance upon it. How could they have known that? These are facts which were absolutely central to the conflict and which were kept hidden both by the agent and by the principal and by the third party supplier. And one can well understand, without excusing, why those facts were kept hidden. Because if those facts were disclosed to the principal, they would, to use the vernacular, run the proverbial mile. They are facts which I suggest, and I've suggested before, should excite the real concern and astonishment of this court.
I think we have that point too. But basically, what you're saying under this head, under this ground, is whether they were sophisticated or unsophisticated is irrelevant because you can't consent to what you don't know, and so it doesn't matter one way or the other whether they were or they weren't.
Yes,
yes, that's the end of the point.
Let me devote 2 more minutes to this submission, just so I can. The other aspect of the judge's decision making is that it would appear that the judge thinks there's a legal world which divides between the sophisticated and the unsophisticated, and you're either in category 1 or category 2, or you're the vulnerable or the non-vulnerable. You're in category 1 and category 2. Now that's just doesn't reflect any aspect of the real world that we all in this courtroom understand. Sophistication is a continuum. Vulnerability is a continuum. You can be sophisticated in some areas. You can be profoundly unsophisticated in other areas. One look at one's own life. I'm profoundly unsophisticated in large numbers of areas, possibly all areas. The idea that one can just say, right, Mr. Gadesley and Mr. Forster, let's put them in the sophisticated category and that's all right then. Somehow we don't need to bother about them. They can look after themselves. It's just a legal misconception. So far as it matters, these were, and I say it doesn't matter, these were gentlemen who were on the shop floor. They knew how to run a factory. I'm sure they knew how to run a factory extremely well indeed. But when it came to the workings of third-party intermediaries and how they went about their business and how they went about making their money, they didn't have the first clue.
Mr. Grant, there are 2 points on there. The first is you can't consent to that which you don't know about, so sophistication is irrelevant. And the second is sophistication goes to the extent to which you need information in order for the point to come home to you. That's in effect how it's been put.
Yes.
And you're saying the judge was wrong to find these people to be sophisticated. That's met by the argument that it's irrelevant anyhow.
That your relationship, as usual, puts it with absolute precision.
So ground 4.
Ground 4, my learning friend Mr. Turner is going to make submissions on when I sit down, unless the court will be assisted by hearing them now.
Yes, let's hear him now. Thank you. Because I think this is a very short point.
It is a very short point, my lady, and my learned friend Mr. Grant has already made most of the submission that I would make in relation to paragraph 225 of the judgment in any event. But let me just explain how this ground developed. Now, when we drafted this ground, it was drafted as a full frontal attack on the judge's reliance on trade custom and trade usage in his judgment, and in particular in paragraph 225. Now, my learned friends, in response to this ground, they abjured reliance on any trade custom or trade usage, and indeed, to be fair to them, they'd not relied on trade custom or trade usage at first instance. This was very much a point that seems to have come from the judge himself. Now, if I could just show you what my learned friends say in their judgment, in their skeleton argument. This is at page 58 of the core bundle.
Yes.
Now, what you see at paragraph 21 is that my learned friends submit that the key facts accepted by the judge in the judgment are as follows, and go on at subparagraph 4 to say that it was a matter of public knowledge and trade practice that energy brokers such as the broker received their commission as part of the per kilowatt hour unit rate in relation to commercial energy supply contracts. And they rely for that proposition on the fact sheet that my learned friend Mr. Grant has referred to but not taken the court to, and in my submission rightly not taken the court to it, because this is a document that my client did not know about. Neither Mr. Gaisley nor Mr. Forster had seen this document. They were not alive.
This is the Ofgem document.
This is the
So
Ofgem.
we were taken to that.
So they were taken to it in cross-examination.
No, we were.
Oh no, you were referred to it, but you didn't want to see it.
We didn't go to the actual page.
Oh, okay.
I went to it briefly, I think, yeah.
I looked at it, sorry. Okay.
If we then turn over to ground 4 itself, we find ground 4 on page 65 of the bundle. And you see it paragraph 39, a recitation of the point just made. And then at paragraph 40, my learned friends say, the judge correctly, with respect to A, accepted that this was evidence that this was a common industry practice and this was in the public domain. And just pausing there, it's only in the public domain in the sense that there is a fact sheet on the internet, a fact sheet not known to my clients, as I've said, but nonetheless relied upon by the judge in the course of his analysis. And my learned friends continue. With respect to A, the judge's findings in relation to scope of fiduciary duty and informed consent are not based on trade custom and usage. And just pausing there, as I've mentioned, my learned friends abjure reliance on trade custom and usage. It would, in any event, be an unsustainable argument if it were to be advanced, because there's no pleaded case of trade custom or trade usage. There is no evidence of trade custom or trade usage. And the evidence that there is simply the fact sheet that I've referred to. And they go on to say, but rather on the fact that A should be treated, pausing there, that language should be treated is language of, in my submission, constructive knowledge that flies in the face of the sort of authorities that my learned friend Mr. Grant has shown you about the absence of a duty of inquiry on the part of the principal. So done in English, Trafalgar, all the cases that we've looked at, or at least which have been referred to. So A should be treated as being aware that the commission payable by R to the broker would be included as part of the per kilowatt hour unit rate that A was paying for their energy usage. They're relying, seeking to uphold the judge's analysis in paragraph 225 on that very limited basis. Now, when we look at the authorities on trade custom and trade usage, whether those are the authorities in Chitty that are in the bundle, whether those are the authorities in Bosted and Reynolds, also in the bundle, or simply Snell, where the point is encapsulated quite well, and I'll come on to show you that. What one sees is that something short of trade custom or trade usage cannot be imputed to a principal who is asked to give their consent to a breach of fiduciary duty. Now, if I could just show you very briefly paragraph 225 of the judgment. I know we've looked at it already, but I'd just like to show you precisely what the judge says. This is at 138 of the core bundle. And we see, my learned friend Mr. Grant read it out, but if we begin from to that extent, insofar as it reflects trade usage and custom, it actually obviates the need for specific informed consent. The judge continues, but that is now simply an irrelevance, given there is no reliance on trade custom or trade usage. all that remains is the following sentence. Insofar as it is not a trade custom, it is simply another brick in the wall erected by the defendant to defeat the claimant's case. But if it's not a trade custom or trade usage, if it's not known to my clients, it's simply an irrelevance when it comes to the analysis of whether fully informed consent has been given. Now, I'm conscious of the time, so I don't want to take you to Snell, but I would just refer you to Snell, where there is a passage dealing with trade custom that makes quite clear that anything short of a trade custom or trade usage is not sufficient for the purpose of the very narrow rule in relation to trade custom and trade usage in the context of secret commissions and half-secret commissions. And so I would simply give you the reference, unless you'd like me to show you.
And the references?
It is page 1468 of the authorities bundle.
That's the last volume, isn't it?
It is. So I would simply say there is no legal basis identified by the judge for that final sentence of 225 and the notion that one sees at other parts of the judgment similar to that. My learned friends have not identified any legal basis for it. I can't identify any legal basis for it, and there is simply none. So we would say that paragraph 225, it simply must go, as should all the references to or reliance that is placed on documents, or this document being in the public domain or being a matter of public knowledge. It's simply an irrelevance, and it's wrong. My lady, my lords, that's all I propose to say.
Thank you very much indeed. So you can move on to ground 5.
My lady, we can. Going back to the skeleton argument, that's tab 3 of the core bundle, and it is at page 37, external pagination, para 61. Now, it is, I think, appropriate to remind the court of the circumstances in which this point arose. I wasn't instructed at first instance.
Why? I mean, it's either a good point or it's a bad point. Why are we interested in spending some time?
For this
over
reason
this.
alone, which is I'm going to take ground 8, new ground 8, proposed new ground 8 with ground 5 because they have an interconnection. And I'm going to, and I quite accept, I've made this absolutely clear in my skeleton argument, that Mr. Brown, the counsel who appeared at first instance, expressly abjured the any suggestion of dishonesty against the defendant and didn't run an argument based on dishonesty. And my learned friends say, well, that's the end of it. You know, you didn't run it at trial, therefore you should be shut out from running it on appeal. And it is a material fact that I say to ground 8, but it explains the argument under ground 5 as well, that skeleton arguments were exchanged 2 days before the trial. And my learned friend Mr. Lord King's counsel and Mr. Cutting were signatories to their skeleton argument, the defendant's skeleton argument. And just as in all the other cases that had occurred up to that moment, there was no suggestion whatsoever that the so-called Hurst-Anger liability was a dishonesty-based liability. And the day before the trial, when Mr. Brown was preparing for a trial against Mr. Lord King's counsel, Mr. Cutting, there was sent to him at about 11 a.m. or so a bundle of authorities, a big fat bundle of authorities containing, amongst other things, Twin Sectra, without any form of explanation as to why this new bundle of authorities, which relates to cases that had been referred to in the skeleton argument, had been served. He then made inquiry and was told, because we are now going to run this new point. And I think my learned friend, in his supplemental skeleton argument, accepts that up until that moment, everyone had proceeded on the basis that the Hurst-Anger liability was non-dishonesty based, and this was a point that occurred to Mr. Lord on that day or the day before, whenever it might be. Now, that explains to a large extent why Mr. Brown, faced with the need to prepare his cross-examination of Mr. O'Connor, and B, the need to make submissions on a very large number of sub-issues, all identified in the list of issues. I think there were 12 of them or so, and they gave rise to all sorts of separate questions. Was there an agency relationship? Was there a fiduciary relationship? And so on and so on. So there was a very large amount of ground to cover. And that may well provide some explanation, or does provide some explanation, for why Mr. Brown was not fully equipped to actually analyse the relevant submissions and make submissions in response to them, and also to draw the court's attention below to the fact that Twin Sectra was very far from being the last word. And essentially the case run by my learned friend below was, look at Lord Hutton's and Lord Hoffman's judgment in Twin Sectra. You've got to know that you've been dishonest. You've got to have a subjective awareness of your own dishonesty. Never put to Mr. O'Connor, not pleaded, ergo the case just disappears. And one can, I respectfully suggest, have some real degree of sympathy for Mr. Brown, junior counsel against a very experienced leader like Mr. Lord, in not having all the relevant law at his fingertips, to enable him to make these submissions. Ergo, he therefore, faced with the perception that Twin Sectra was the last word on the case, on the subject, felt unable to run a case in dishonesty, although of course he maintained his position that Herstanger did not require dishonesty, and I suggest this court should be sympathetic to that to that predicament that he found himself in. I'll come back to that a bit more detail.
Did he seek an adjournment?
He did not.
No.
He did not. My lady, I'm at ground 5. I've just elaborated some of the points that I made in writing at paragraph 61 and 62, and the matter is dealt with by the judge in his judgment at paragraphs 228 to 246. We might just look at those paragraphs. Page 139. This is under the question, did the defendant procure any breach by UW? Which is following the language of Herstanger, as the court will recall. And the first submission that was made by Mr. Brown was that Herstanger makes clear that it is not a dishonesty-based liability. Mr. Lord made a submission that no, Herstanger, insofar as Herstanger said that, it was dealing with fully secret commission cases only. That's just not right, with the greatest respect. I think my learned friend Mr. Lord now accepts that, because he himself is driven to argue at para 46 of his main skeleton that Herstanger was wrongly decided, and how your lordships and my lady could come to that conclusion, given that you're bound by Herstanger, is a mystery to me. But anyway, that's the submission he will no doubt elaborate tomorrow before my lady and my lords. We then have some analysis of the various submissions that were made by the parties, and the central question is set up at para 239, page 141 of the external pagination. All is essentially irrelevant if accessory liability depends on dishonesty. The question is, does it? And then the court quotes from Lord Hoffman, from Twin Sectra. He then quotes from Lord Hutton, from Twin Sectra 241. He then quotes from a Fiona Trust, with the greatest respect to the judge, I think it was Mr. Justice Andrew Smith, who decided Fiona Trust. It's not apparent why the judge might have thought that Fiona Trust was a relevant authority to quote, as opposed to this court's decision in Group 7 or Supreme Court's decision in Ivy and Genting, or the Privy Council's decision in Barlow Clowes. I'm not entirely clear why that was the case, other than the fact that none of those cases were actually cited to him, and arrives without any consideration of Herstanger at the conclusion he arrives at paras 244 to 246. That's the decision of the court below. And he says, well, I find it is a dishonesty-based liability, and there was no dishonesty, and therefore claim is dismissed. My lady, I've already to some extent anticipated a number of my submissions in this area. I make my submissions based on two broad grounds. The first is that Herstanger makes abundantly clear in relation to a fact pattern that is absolutely the simulacrum of the fact pattern on display in this case, that the liability that it recognises, viz. A liability to pay equitable compensation in the amount of the bribe paid, or secret or half-secret commission paid by the third-party supplier to the agent, is amenable to an order of a quasi-restitutionary nature, albeit under the label equitable compensation rather than money had and received. And I've made the submission already that the...
Sorry, can you just take that more slowly for me?
Yes, please. What the Court of Appeal in Herstanger recognises is a non-dishonesty-based liability on the part of the third party who has paid the half-secret commission to the agent, and that's a liability to pay the amount of the commission that it has already paid to the agent, to pay it over to the third party, the principal. And that exactly mirrors, to use the language of Lord Justice Tuckey himself at paragraph 48, that mirrors the common law action in money had and received.
What does that mean? So what's the cause of action in play? He talks about accessory liability for the breach of fiduciary duty.
Well, it's a liability which is for procuration, because that's the language that he fastens upon in the relevant paragraphs. Let's go back to it. Tab 23.
I know he said it, but just for a minute. Money hadn't received. I mean, I'm not going to take it quite so literally, or restitution. It's asking the person who on this footing is paying the commission to pay it again, to pay a second amount
Right.
again.
Quite.
So money had and received.
Right.
Just struggling with that as a
Right,
concept.
my lord, can
and
we-
restitution, struggling with that as a concept.
Can we pause there? It's a very important point, which I was actually going to come to, and I'm very glad, and your lordship is as ever ahead of me. Let's go to the first, because as my Lord Justice Zacaroli said, it mirrors, to use the precise language of Lord Justice Tuckey at paragraph 48, page 487 of the external pagination. Right, let me just take it a little further up the page. The defendants, i.e. the people in my shoes, have a claim for equitable compensation against the claimant as it procured the broker's breach of fiduciary duty. This mirrors the common law right to claim the return of a bribe as money had received. Now, this takes me to my second broad submission. My first submission is just Herstanger is binding and makes clear that I win on the facts as found by the judge. But I want to go further than that and actually explain why Herstanger is not only precedentally binding on you, on this court, but is actually right. And that involves me taking two steps back and starting, as my lord rightly says, well, what about the actual underlying cause of action that it is said to mirror? The cause of action in money hadn't received. Now, my lords, my lady, the law of bribery has, of course, developed over the years and has been the subject of a lot of legal development over the decades. The first case that recognised the idea that where a briber pays a bribe to the agent of the principal can maintain an action against the briber and the agent for money hadn't received, was a case called Grant and Gold Exploration, a case I'm sure this court has had cause to look at in the past. That is tab 8 of the court's bundle of authorities. That's bundle 1 for those with hard copy. And the relevant paragraph, or page rather, of Lord Justice Collins's judgment is 248 and 249. And the breakthrough that was made in that case was that the principal's right of action was not a purely loss-based right of action. Now, of course, it is recognised and still recognised now that the principal whose agent has been the subject of the bribe has a whole array of remedies available to him or her. One of them is rescission, one of them is an account of profits, one of them is damages for the tort of bribery. And of course, that if you're going to seek damages for the tort of bribery, then you have to, like any other claimant in a tort action, prove your loss flowing from the breach. Now, what the new development in Grant was the recognition by Lord Justice Collins, halfway down page 249, that there was additionally to the claim in what he described as deceit, but I think we can probably describe now as the tort of bribery, was the claim for money had and received. Now, I immediately accept that there is an interesting conceptual question as to why the person who's paid the bribe payer, should be liable in restitution to pay the bribe a second time. Now, it's fair to say that in that case, Lord Justices Vaughan Williams and A.L. Smith expressed themselves rather more hesitantly about that question of the right to claim on a non-loss based analysis, i.e. for money hadn't received. But the law was then reconsidered some months later in the case of Hovenden and Milhoff, tab 7 of the court's bundle of authorities. Now, that's a mercifully short report, albeit the judgments are, in the usual way, packed full of important legal analysis. That was a case where some purchasers bought cigarettes and cigars from the suppliers, being Milhoff, being the defendants. And they spent over a period of time £28,000 on the cigarettes. Now, it became apparent that Milhoff had paid their buyer's agents, the plaintiff's buyer's agents, i.e. their fiduciaries, £700 by way of some sort of secret commission. And a claim was brought in various rights of action, and the jury held that the plaintiff had suffered no loss. The £28,000 they'd spent was a perfectly proper price to pay for the cigarettes and the cigars. And notwithstanding the submissions of Mr. Marshall Hall, the Edwardian bar was clearly a very versatile place, for the respondent, that the cause of action in bribery had to be loss-based. The A.L. Smith, Lord Justice A.L. Smith, now recognised and acknowledged the right of action in money hadn't received, page 135, and did so based on the fiction, the irrebuttable fiction, which has now become absolutely embedded in our law, that where a vendor sells to its purchaser at a given price and pays a sum to the agent of the purchaser, so just exactly these facts, but we're talking about energy rather than cigarettes, then it is presumed to have profited to the tune of the amount of the bribe. It's presumed to have been willing to sell the goods to the purchaser for the purchase price less the bribe. And that is just whether that's true or false is an irrebuttable presumption. And we can see Lord Justice A.L. Smith at the bottom, page 135, at the bottom of the right-hand column, says he has in his pocket £700, that is the vendor, money of the purchasers, that £700 he must disgorge. That is the first cause of action here. When a purchaser finds out this state of affairs, he may call upon his agent or the vendor to disgorge. The third person was bound to pay back the extra price which he had received, and he could not absolve himself or diminish the damages by reason of the principal having recovered from the agent the bribe which he had received. When it was proved by, and then so on and so on. And Lord Justice Vaughan Williams, as in the words of Lord Diplock a few years later, recanted the views he'd expressed in Grant and set out, he now embraced the cause of action in money hadn't received in his judgment, first column at page 136. And Lord Justice Romer did the same. And it's fair to say that Lord Justice Romer's judgment has been of enormous significance to the future development of the law of bribery. Now, by the time the matter comes before the House of Lords, the Privy Council in Mahesen, 80 years later, we can go to that. That's tab 15 of the same bundle. The question of the nature of the cause of action is again in issue. And Lord Diplock engages in a learned disquisition on the development of the law from pages 380 or 379 onwards. He, with respect, rightly decides that Hovenden opened a new chapter in the law of civil remedies for bribery, bottom of page 382 of the internal pagination. And he explains at page 383 that the law is now too well established in England to doubt that where a bribe is paid to the agent, then the principal has a claim in the form of action of money hadn't received against both agent and bribe payer. This is 383 G and H. And it's fair to say that his lordship acknowledges the conceptual difficulties that may raise. That's at G of page 383, but says that the law has now become clearly established. Now, in fact, on analysis, with respect, there are no such conceptual problems because the liability of the bribe payer in money hadn't received is simply a recognition via a legal presumption which is irrebuttable that the amount of the bribe equals the amount of the overpayment by the principal.
You say on the facts of this case, actually, it fits very nicely because you say
Quite.
the amount of the
Perfectly tailored.
payment for consumption is increased exactly by the
Exactly pro tanto.
commission. Yeah.
Exactly right. Now, that's the law of money hadn't received. And I hope that answers, or at least goes some way to answering my Lord Justice Snowden's question about the restitutionary nature of the claim in bribery. Now, let me now.
How does it? I mean, does it also work that you would be able to recover against somebody? You'd say if you'd have been relying on it, some part of the campaign commission.
My Lord, we do not make a claim.
I know you don't.
And it would be. I mean, I was discussing it with my juniors over the short adjournment about whether, because there was a lot of money is paid, and it would be an odd outcome, as I accept, if people in my client's position were able to charge to sue for the 2 million of time and time again. That would be an outcome which I suspect would not commend itself to this court. But of course, you can't divide up that 2 million. You can't identify some portion of that 2 million as relevant to my case. I don't think.
In concept, the campaign commission would give rise to a remedy or not, you say?
Well,
I mean, against either the broker that received it or the energy company that paid it, the supplier that paid it.
the difficulty, because the matter was never raised at trial, is not subject to the pleading or anything else. So it's never been investigated. But the difficulty I perceive is that you have the broker receiving a flat sum of £2 million, where it has presumably dozens or hundreds of customers who it's putting Engie's way, and who are all being effectively shifted over to Engie in order to make sure that 2 million or that 5 million, whatever it may be, is kept firmly in the bank account of Utilitywise. And how could what claim could, I mean, there could be hundreds of, putting aside Utilitywise's insolvency, hundreds of claimants having a pop at that 2 million. How that would work out, I can't begin to, at the moment. If I had more time, I no doubt could, but I've got half an hour left to make my submissions, which is not a criticism, I should say, but but where does that take us? This, looking at these various authorities in the law of bribery, where does that take us as regards the Herstanger liability as I describe it? Well, what it does in my submission is this: what it shows is that the ultimate underlying mischief behind the law of bribery is the fact that a bribe or a secret commission, however one wants to characterize it, creates the risk of a conflict between duty and interest on the part of the principal's agent. That is said in Wood. It's said very recently in the Supreme Court in Privinvest, paragraph 86 of Lord Reed's judgment there. It's said time and time again throughout the cases. And what the law's response to that concern about the potential for subordination, whether conscious or unconscious, on the part of the agent, is to create a strict liability on the part of the bribe payer, which is, as I've said earlier, in no way founded upon or influenced by the bona fides, the honesty, the intentions of the bribe payer. So, to take an example, the bribe payer may make a payment to the agent and may seek from the agent an absolute certified assurance that the agent has passed on the fact and circumstances of the commission to its principal. And the agent may provide a certificate to say, on this hypothesis, yes, do not worry, I have made full and absolute disclosure of the commission you have paid me to the agent and the principal, to the principal. And indeed, the third party may be, on the facts of a given case, entirely justified in believing what the agent has told him or her. So let's postulate those facts. Now, let's say that the agent has lied to the commission payer. Let's not use the word bribe, although it is a bribe in law. The commission payer has lied to the commission payer and has in fact withheld that information from its principal. Now, in that scenario, the principal has a claim against the commission payer for the amount of the commission, wholly irrespective of the commission payer's bona fides, honesty, intentions, and motives, through a series of irrebuttable presumptions that find their genesis in Lord Justice Romer's judgment in Hovenden and have been repeated many times since. So it is a strict liability which is dependent solely on proof of two things, as I've said before: knowledge of the agency and knowledge of the fact of the commission, which of course is a given that the commission payer is paying the commission. Now, if my learned friends are right on their interpretation of what the law should be, then they say, aha, that's the bribe situation. That's a different situation. We're in a half-secret commission scenario. And they say that involves an entirely different basis of liability. Now, to show why that is fallacious with respect, let me just nudge the facts of the scenario I've just given you. The commission payer makes the payment. It contractually requires the agent to make full disclosure of the commission to the to its principal, and instead of simply giving a certificate which is false and not making any disclosure at all, the agent lets slip in a conversation, such as the type of conversation we see transcribed in this case, some elusive remark about the fact that some form of commission is paid or payable by the principal. Now, the commission payer's own position is entirely unaffected by what has privately been said by the agent to its principal. But on my learned friend's analysis, because of a fact which is entirely extraneous to the decision-making or behaviour of the third party, its liability, through some legal alchemy, stops being a strict liability, which is irrespective of its honesty or motives or etc., but becomes a liability based in dishonesty. Now, my suggestion to this court is that legal rules are required to be rational. One has to have a rational legal system. Now, the idea that because of, in a given scenario, the agent in a phone call with its principal makes some veiled reference to the fact of the commission, suddenly converts the principal, whose position is otherwise totally unchanged, from a strict liability in bribery to a dishonesty-based liability in the tort or in the equitable wrong of dishonest assistance, is irrational and preposterous. Because why should the principal is in exactly the same position itself in scenario 1 and scenario 2. All that differs from scenario 1 and scenario 2 is that the agent has chosen to make some veiled reference to the commission so as to turn it into a so-called half-secret commission. Now, the idea that suddenly, by reasons of matters that are entirely outside the power and behaviour of the third party, its liability suddenly engage in some sort of transmogrification is, I say, would be an affront to the legal system, the need for rationality in a legal system. It would also be an affront to the fact that whether you have a commission or a secret commission, the underlying mischief behind both and the underlying concern of the law behind both is the subordination of the fiduciary or the agent. And the law has said very clearly that even in a half-secret case, there necessarily and definitionally has not been fully informed consent, and ergo, there definitionally has not been consent and ratification and authorization of the fiduciary breach. Ergo, there remains a fiduciary breach. Ergo, the mischief alighted upon most recently by Lord Reed in Privinvest at paragraphs 86 and 87, i.e. the concern of the court and the law to ensure that conflicts are not created by commissions, is equally at work in the fully secret case as it is in the half-secret case. And that is why Lord Justice Tuckey so wisely, if I may respectfully say so, in Herstanger, suggested that the only distinction in practice between a half-secret case and a fully secret case is the scope of the remedial response, and why he said in that case that the action, albeit dressed up in an equitable wrapping, for the recovery of the commission was a simulacrum of the action for recovery at common law for in money hadn't received.
It follows from your submission, doesn't it, that there shouldn't be any difference at all between a half-secret commission and a fully secret commission?
Well, I don't accept that.
Well, what is the logic? Well, what do you say that is the logic for the law making any distinction between a fully secret commission and a half-secret commission?
I can well see that the law might arrive at that but not can't do it. I'm not whether it can do so at this level. I don't know. But Herstanger makes that distinction, and Herstanger makes that distinction by reference to the fact that in the fully secret case, the finding of constructive fraud would be unfair, even though it's a constructive finding. I accept that, but nonetheless, the third party should not be acquitted fully, and arrives at an accommodation which is not in terms of the underlying ingredients of the liability, which are the same. Knowledge of the agency, payment of the commission. What Johnson says at para 173 and 138 is what I've shown the court. Even importing dishonesty, what the distinction that it makes is in the remedial distinction. And I suppose the court was straining in a new situation that was confronting it in 2007 in Herstanger, was straining at seeking to accommodate two conflicting desiderata. One was to reflect the fact that in that scenario there was not full secrecy, but on the other hand there was not fully informed consent, and the law, in the way that it often has to do, the law is judge made, and at the end of the day there is a first case for everything. And as I think was famously said by one of the great judges of the last 50 years, equity is not past the age of childbearing. And I think it's fair to say that Lord Justice Tuckey was conscious that he was breaking new ground in response to a scenario that had yet to find any form of articulation before the courts. And that's been said.
And
on
the
a
only
number of
difference that Lord Justice Tuckey makes is that in the half-secret situation, the remedy is discretionary in relation to rescission,
Quite.
Rather than being of right. So that's the only difference.
That's the only difference that Lord Justice Tuckey makes, and I embrace that. Might I just?
But do you accept that the distinction between a third party who makes a fiduciary who makes some disclosure but inadequate, and a fiduciary who makes no disclosure at all of the fact that he's going to receive a commission, is a legitimate distinction for the law to draw? I thought you made a submission a little earlier on that since they're both to do with suborning or failure by a fiduciary to perform his functions, it should make no difference.
Well, what I tried to say was that the underlying mischief against which both the law of fully secret commissions and half-secret commissions is set up to guard against is subornation. And it might be said that there is a rational basis for saying that in the fully secret case, the risk of subornation, putting aside the law of fully informed consent, is greater than in the case of half-secret commission. I don't need to go as far as to say that this court should simply sweep away the distinction and say the remedies are the same in both cases. That may be a decision for this court that this court wants to make. Of course, I wouldn't wish to dissuade it from doing so, but it's no part of my to win this appeal, to succeed in this appeal. I do not need to suggest to your lordships and my lady that there's simply, let's just have one law of secret or fully secret or half secret. They're all the same, because in no case, in either case, there is not fully informed consent definitionally. That is one response the court might entertain, but it doesn't need to go so far as that for my case, for my claim to succeed, because I am, even if it is a half secret commission, and even if there is this jurisprudential distinction to be drawn, the distinction, as my lady rightly said, merely relates to the extent of the law of rescission, and I'm not seeking to rescind anything. I'm just seeking the equitable simulacrum of the Hovenden and the Mahesen liability, where the actual constituents of the cause of action are precisely the same.
So can I asked you this morning where the result in Herstanger came from. We had a discussion about how it's been recognised since, but I don't think I got an answer to where it came from. Your answer now, I think, is it's new. Herstanger is the case where equity has given birth to a new principle.
I think I think
But-
that
so-
point has been made by judges subsequently.
Let me just take my question then.
I apologise.
What is the principle? Is it, as it appears to be, a new species of accessory liability for breach of fiduciary duty,
No.
one which does not require dishonesty?
No, it's
or is
not.
it just inventing a new equitable version of money had and received?
It is a whether it's inventing a new version of money hadn't received, it is a version of money hadn't received. There's no doubt about that, because it leads to the same remedial outcome, precisely the same, and it has the same constituent parts, knowledge and payment. But the way that it is framed is not as an accessory liability, because if you look at paragraphs, I think it's 42 and 48, or 45 and 48, Lord Justice Tuckey uses the word procuration. And those are that is a very well chosen word with respect, because this is not dishonest assistance, as your lordship knows. You can be a dishonest assister in pretty tangential ways, just by providing some measure of assistance. It doesn't need to generate loss, but you can still be ensnared in the overall net of liability. Here we are a million miles from that kind of accessory liability. We are here, as I've said before, and I'll say once more, I'm sorry to repeat myself, we are here in a scenario where the breach has been flatly and solely procured by the supplier through the arrangements it has entered into and its willingness to pay commission, which is down to the supplier doesn't need to agree these terms. It has agreed these terms.
And so what was Lord Justice Tuckey doing at paragraph 34 when he said a third party paying commission, knowing of the agency, will be an accessory to such a breach?
He was using the word of accessory. I suspect he was, I mean, I don't know, but he was using the word accessory in a way that then was more accurately referred to as procuration at paras 45 and 48. That's the only use of the word accessory. But the critical point is, it makes no sense for there to be a strict liability in my scenario one. The phone call doesn't involve any mention at all. But in scenario two, where there's a few words are laid out, suddenly we're in a different legal framework. It's senseless and irrational. And this court should not countenance that. And that's the wisdom of Lord Justice Tuckey's judgment, in my respectful submission. My lord, my lady, I'm conscious of the time. There are three judgments which I just wanted to very briefly touch upon, which relate to this. There is the decision of Mr. Justice Finn, it needs no introduction, in Grimaldi at tab 27 of the authorities bundle, and that is at bundle 2. A long judgment in the Federal Court of Australia. But if we just go very briefly to paragraph 193. Where, having referred to various famous cases in the English law,
What paragraph?
193, page 576. Finally, as both of the above quotations, one from Deridian, well-known decision, of course, of Mr. Justice Lawrence Collins, the payer of a secret commission to a person known to be acting in the matter on behalf of another is taken to assume the risk of the payee having not obtained his or her principal's informed consent grant, knowing that the payee is acting on behalf of another's behalf, is sufficient of itself to attract liability unless full disclosure is made by the payer or agent and consent is given by the principal to the payment. Importantly, the payer's liability does not turn on his or her knowing or suspecting that the agent has not received the principal's informed consent to the payment. And I see that captures the essence of the nature of the liability. And whether it's secret or half secret, the outcome should be the same. Subject to, I'm not in any way doubting the precision analysis. His Lordship refers to Deridian, which is at tab 21, which again is worth very briefly touching upon. That is in bundle 2, same bundle, tab 21. Again, I haven't got time to go through it. If I could just invite the court to look at paragraphs 53 and 54. Where, interestingly, His Lordship actually makes a distinction between just a strict liability money hadn't received and an accessorial liability. It could give rise to both. And also sets out the absence of a need for a corrupt motive, etc., etc. And finally, so I think I may have, yeah, that's tab 21. And finally, could I go to Mr. Justice Marcus Smith's decision in Pengelly, which went on appeal to the Court of Appeal in Wood. And it's a passage my learned friends themselves cleave to and rely upon in their skeleton argument. But I agree with them. It's tab 41, page 975, where Mr. Justice Marcus Smith, as 975, top of the page, paragraph 21.1, says this: it will be necessary to consider exactly what is meant by a half-secret commission, and to be clear, the term is not that of the judge's making, but arises out of the decision in Herstanger. In essence, however, a half-secret commission is a secret commission or bribe paid to an agent where there's been partial but not full disclosure to the agent's principal. Of course, where there's been full disclosure to the agent's principal, and that principal has provided his or her informed consent, there is no bribe or secret commission at all. A half-secret commission appears to seek to describe that variety of cases falling short of informed consent, but where some level of disclosure has occurred. My learned friends agree with that analysis, and so do I, with respect. But what it shows is the common origin. They're not two separate legal conceptions with two separate legal frameworks attaching to them. That's all I wanted to say about ground 5. Ground 8, I have dealt with relatively, I have to some extent outlined already. I will spend 5 minutes on that if I may. I accept, and I've set out the reasons, that dishonesty was not run at trial, an abject. What we say now is that having seen the decision in first round, and I've shown you the relevant paragraphs, we have sought and we seek to introduce this new ground. There is no complaint by my learned friends of any prejudice to them. They take the point, and they're perfectly proper point for them to take, that the point was not run at trial and should not be allowed on appeal. It wasn't, they say it wasn't pleaded. Well, one can look at the pleading, and of course the word dishonesty is not required to be used. And we say that in fact, on the analysis of dishonesty by the Court of Appeal in Johnson, the pleading is sufficient, and I would invite the court to look at that. I don't have time to go to it. But what we say is that by reference to the law as stated in Johnson, and by reference to what was found by the judge below, then if I'm wrong on ground 5, then I should succeed on ground 8. And I've already set out the facts that the judge found. Knowledge of agency, knowledge that the payment to the commission gives rise to a conflict of interest, knowledge that the broker would not make any disclosure, not that that's actually necessary, but for good measure I make it. Knowledge that the broker would not tell his principal of the bribe, of the payment, sorry. Those are all findings made by the court. They're all common ground points. And we say, through the lens of Johnson, it is absolutely clear that on those findings, that constitutes dishonesty as interpreted in Johnson, and I've already made some submissions already about this by reference to the analysis in Group 7. Now,
Just to be, I'm sorry, I understand this. Your case here is assuming dishonesty is required per paragraph 1, 2, and 7 concession.
yes,
In Johnson, it means dishonesty as explained at 136 and 137.
well, it's explained in
Up to those paragraphs.
it's explained in a lot of detail throughout, and I just haven't got time to take
Well,
your.
no, but it's critically that point, isn't it, where they say it isn't necessary to establish dishonesty to show that the lender or the supplier here was knew or turned a blind eye to the fact that there had been no fully informed consent.
Quite. Well, except here, of course, there is knowledge, because Mr. O'Connor himself admits in cross-examination. I took the
I hear
call.
that, but the legal, that's the legal test you say we're to apply on this, on your ground.
And it's patently applicable here, we say, with respect. And this court should not shy away from making the relevant finding where there is literally no prejudice to the defendant. No one suggests that, a different.
Normally, when you're making a finding of dishonesty, or you're being asked to make a finding of dishonesty against an individual or somebody, in fact, it has to be against an individual, doesn't it? It's a point we raised in an earlier point. Don't you need to identify an individual whose state of mind is to be attributed to a company? You need to say that state of mind is dishonest. You need to identify the person.
Well, the Court of Appeal in Johnson appeared to have no such concern.
Well, okay.
I don't see them making any findings against individuals. But B, if there's anyone,
Okay,
it's Mr. O'Connor.
I'm asking you
Mr. O'Connor.
whether it is, in fact, conventional when you're making a finding of dishonesty. First of all, in relation to a company, first of all, to identify the individual whose state of knowledge is attributable to the company. And we discussed this morning, there are plenty of authority that you can't aggregate states of individuals' minds and then say, hey, the company is dishonest because Mr. A knew certain things and Miss Y knew others, and put the two together.
No, I accept.
So you have to identify an individual whose state of knowledge is attributable to the company. That's the first stage, subjective. You then say, in accordance with the standards of ordinary honest people, is in an objective way, is that dishonest? Right. That's the way the court does it. Usually, in fact, I'd say almost invariably, when you're engaged in that exercise at first instance, you have the person whose state of knowledge is said to be attributable to the company in the witness box. And it's normally essential to put to that person the suggestion that they have acted dishonestly,
No.
simply to understand whether they have an answer to it.
No.
Are you saying that it's unnecessary to put to an individual that they've been dishonest? You just need to put to them the state of knowledge and nothing more.
Guiding myself from my lady's judgment as part of the court, I should say, in Group 7, what the court needs to do is ascertain the facts that were known either by the individual or the company. And here I've set out the facts that were known by Mr. O'Connor, and no one suggests his knowledge should not be attributed to the company. I'm not seeking to invite the court to make any further findings. I'm basing myself on findings made by the court below based on the evidence given by Mr. O'Connor. Obviously, in order to invite the court to make findings, one has to potentially, unless they're admitted, put points, or unless they're part of the evidence put forward by the defendant's witness, one may have to put points. But given that make suggestions or put particular points, it's very much dependent on what the witness statement itself says. And here, the witness statement is very helpful. Mr. O'Connor's witness is very helpful, as I've shown the court, to my client. You don't have to say, and that was dishonest. You don't have to say it, because the question of whether Mr. O'Connor personally thought it was dishonest or not is entirely irrelevant. Because as Ivy tells us, as Group 7 tells us, the two-stage test is ascertaining the facts known by the entity, and that may involve an element of attribution, but no one suggests that the knowledge of Mr. O'Connor, he was after all the only witness that turned up to give evidence, should not be attributed to the company. And then you ask, based on that knowledge, was the behaviour of the defendant honest or dishonest? And Mr. O'Connor cannot assist in that inquiry because it's an objective inquiry. It may have been important under the rule of twin secture, but that rule and that dispensation has long gone, and Lord Millett's dissenting judgment has prevailed. Hardly, not very surprising when we think of Lord Millett, has prevailed, and has prevailed with the Privy Council. Lord Hoffman's very elegant recantation, if I may call it, in Barlow Clouds, and the rest, and the other cases which this court knows so well. So there is no difficulty in making the finding that I'm inviting the court to make. And I just note that the Court of Appeal in Johnson, where there was no suggestion at first instance, there was no pleading about dishonesty, nothing, there wasn't even a case made about dishonesty in the skeleton argument.
So
And nonetheless, the Court of Appeal had no difficulty.
So I think the reason I've been asked you, I assume your answer to the point that this should not be allowed on appeal because the course of the trial below would have taken a different turn, is you say it wouldn't have done.
Well, and my learned friends don't suggest otherwise. They've put in a supplemental skeleton, a long supplemental skeleton. You have it in the core bundle. The sole point they make in their supplemental bundle, in their supplemental skeleton, I want to be very fair about this. It's in the core bundle at tabs 6, I think 6. If we go to para 25, page 87. Where, I mean, they're, I think, fairly and realistically, their attempt to shut out ground A might be described as formal rather than substantive. It's basically paragraph 25. There's no suggestion of that, oh, the course of the trial would have been different, we've been prejudiced. They just make the point, and they're entitled to make it, that it had been eschewed at first instance by my client via their counsel, in the circumstances I've explained. But what they then do is actually meet the meat of the submission.
Okay. To be fair, they do make the point I put to you, which is that it should have been put to the witnesses. You say actually those cases that they rely upon are what? Either wrong or before the modern understanding of the objective nature of dishonesty.
Well, I think my learned friend will seek to persuade you that twin sector remains the prevailing case. I mean, it's plastered all over his submissions at first instance and all over his submissions on appeal. And obviously that'll be a matter between for your ladyship and my lords to consider. But to say, and you were dishonest, weren't you, Mr. O'Connor? No, I wasn't. I mean, how does that help the decision making? Not one iota.
Okay, so that's the answer to the point that it wasn't put to witnesses and it should be.
Exactly. My lord, my lady, I'm conscious now. I've got 2 more grounds to cover.
Yes.
I pray and aid the fact that we only started at 2:45 because of the 11:15 because of the problems with openness. If your ladyship would be willing to sit at, I say this hesitantly, without any presumptions either way, to sit at 10 a.m. tomorrow and to give me 20 minutes, then I will be finished.
I have to say, Mr. Grant, I have been warning you all day about timings and how close to the wind you were sailing. Nevertheless, you've not covered 2 of your grounds of appeal. I'm willing, as long as it's not inconvenient for either of my colleagues, to sit at 10 a.m. tomorrow.
I'm extremely grateful.
But on the basis that Mr. Lord will be able to commence his submissions no later than 10:30, and so no more time than that.
I'm grateful, my lady. Thank you. And I'm grateful to my lords as well.
10 a.m. then. All right, okay.
confused myself.